In this installment, we're going to talk about the instructional program and how important the instructional program is as far as the legal obligations in school law. Legal authority for defining the curriculum of public schools resides with state legislatures, and this duty is generally shared between the legislature and a state board of education. In a few states, based on constitutional provisions of those states, Kentucky is one of those. The legislature, at its discretion, prescribes the basic course of study, testing, graduation requirements. In most cases, the legislature delegates curriculum matters to state boards and local school districts and boards of education. Almost every state, in fact, every state, requires children between certain ages to attend public, private, or home school. The ages of compulsory attendance vary, and the ability of who sets that compulsory attendance. For example, in Kentucky, compulsory attendance is 6 to 16, but many school districts are allowed to go to 18. The case Biting v. Lee is a New York case in which the school's policy required students to attend 90% of classes in each course to graduate, and the policy required schools to drop students from any course in which they had been deliberately absent. A group of students brought suit alleging the denial of credit for class. It's tantamount to dropping a student from enrollment, which is contrary to state law, compulsory attendance. The district filed a motion for summary judgment, which was granted by the court, and the students appealed to the New York Supreme Court. The court rejected the students' argument, held that the denial of credit was not equivalent to being dropped from enrollment, and it did not prevent them from attending class or makeup classes. And so reasonable attendance policies are supported by courts where students deliberately fail to attend. Academic credits may be lost when students willfully fail to attend, and states have the discretion to allow certain exemptions, but parents who violate compulsory attendance laws may face criminal charges, and students who violate these laws may be suspended or expelled, depending on their severity. Truancy involves intentional and unauthorized absence from compulsory schooling, and truancy also involves unexcused absences by students without parental knowledge. Depending on the number and authorized absences, a student may be denied course credit, days that are made up through detention or summer school. Some states penalize parents if the compulsory age students are truant on a consistent basis. And these penalties may include fines or jail time. School districts employ attendance officers in Kentucky called a director of pupil personnel. Actually, the only other job besides a superintendent that has to exist in a school district at the district level. These officers monitor students who are truant based on policy. Students may also be prosecuted in some states for violating truancy. School vouchers are an increasingly controversial subject, and the tax credits that are now becoming trends as well. They allow parents to cover their child's education through the use of city, state, federal funding. The amount of the voucher is generally comparable to the amount that is allocated to public schools for that child's education. In Kentucky, around $4,000 per child. Those who support vouchers suggest that they weed out poorly run schools, thereby allowing parents to choose good schools for their children. They cite more parental choice, and they also cite the ability to find opportunities that match their child's needs and their skills more readily. Those who oppose vouchers argue that only parents of good students choose vouchers, leaving children in schools that are those that have parents that aren't as engaged in their education. Additionally, they cite the risk of creating segregated schools as widening gap between the haves and have-nots. The Zellman-Simmons-Harris case is a case before the U.S. Supreme Court that held that vouchers issued to parents of students who attended parochial schools did not violate the First Amendment separation of church and state. This is an evolving issue. As we talk about trends in law, we'll see how these trends are really citing toward increased prevalence of vouchers and tax credits to allow more choice. Almost every state has provisions allowing for homeschooling. Minimum standards for homeschool vary among states based on each state's compulsory attendance laws, minimum standards for curriculum and instruction, length of instructional time, and the number of days to be provided. They're generally prescribed by statute or by the State Board of Education. Occasionally, conflicts arise between parents and the state regarding the rights of parents in homeschooling their children. There are several of these private school cases that, or homeschool cases. In most cases, they allow the state to make reasonable rules, like governing the qualification of those that teach. Kentucky standards for homeschool are very weak compared to many other states. One other interesting case is the Pierce versus Society of Sisters. This is a case that affirmed the legality of private school education. And so the Pierce case indicated that the state cannot outlaw private or parochial church-oriented schools. Health requirements since the age of COVID have also become very controversial. States, through their police powers, have the responsibility to protect health and safety and welfare of children in public schools. Through these powers, some states typically require medical exams and certain immunizations as a prerequisite for admissions. The most common challenge faced by school districts as agents of the state are objections to immunization by parents who claim that immunization violates their right to free exercise of religion. The courts, for the most part, have supported school districts in their requiring specific immunization to prevent communicable disease. Courts have viewed the state's interest in health and safety and well-being of students as more compelling than the parents' interest. Consequently, parents have been convicted and fined for failure to have their children vaccinated as a condition of admission. Some states do allow, like Kentucky, certain exemptions so long as the welfare of other students is not jeopardized. The case law is still evolving on this, especially since COVID, and a lot of the legislation is starting to evolve and try to change the vaccination requirement. But so far, the courts have held that these requirements are legal. Residence is another area where public schools have a leading responsibility to educate those who reside in their boundaries and the resident of a student's actual dwelling place. A student may have a domicile, which is where the student intends to remain indefinitely. An example of a court's position that schools must educate school-age children who reside within their districts with the intent to remain is illustrated in several cases, particularly cases where where grandparents and others that are not legal guardians will have their children living or grandchildren living with them over a long period of time. The schools that have fought that have all lost, and in every case, a child is entitled to a public education, even though his parent or guardian may live elsewhere. Physical presence in a particular place for an extended period of time with the intent to remain is tantamount to establishing residence as viewed by the courts. Curriculum standards are another really interesting element of what is happening with the instructional program in schools, especially in the heated debates about critical race theory and special interest groups. The minimum curriculum standards in schools are established by state statute and policy, and certain courses and minimum achievement standards are determined through that policy. Local districts can establish additional standards as long as they don't contradict state requirements. The courts have very, very reluctantly intervened in matters involving school curricula based on the view that the states retain authority to establish the curriculum standards and require compliance as long as there's no federal constitutional infringement. Although curriculum matters are best left to educators, it does not negate challenges by parents regarding content-based issues involving textbooks, other books, and curriculum materials. Special interest groups especially are those that have attempted to influence discussions regarding school curriculum with regard to textbooks and library books, and also matters around critical race theory, the AP African American Studies, and several other aspects of gender-oriented books and materials. Special interest groups tend to be conservative and oftentimes base opposition in certain school books due to political, religious, or philosophical viewpoints. In some cases, these groups raise objections to certain content that is inconsistent with their values. They do so without regard to the overall literary value of the work itself. One of the most prominent cases that's not listed here is the Counts v. Cedarville School District, which is an Arkansas school board that voted to restrict the Harry Potter books based on the view that the books promoted disobedience, disrespect for authority, witchcraft, and the occult. Consequently, students in the district were required to obtain signed permission from their parents and legal guardians to borrow those books. The district court overturned the board's decision and ordered the books returned to the unrestricted area. And it's really hard to, the courts are very supportive of students' First Amendment right in a school setting. The right to read a book is an aspect of the right to receive information, and the library is an environment where that recognition of First Amendment rights is ever present. The courts take that pretty seriously. As far as grading and academic requirements, there's very little that the courts have been willing to weigh in on as far as in being involved in that. They're reluctant to interfere in cases involving academic matters. The prevailing view of the courts is that academic matters are best handled by professional educators, particularly those involving student evaluations. So courts further recognize that there's a certain degree of subjectivity in evaluating students and grading them. So requirements regarding student progress from one grade to another typically are not reviewable by courts unless there's substantial evidence of unreasonableness. And the case law is very supportive of that. Foreign language instruction was originally challenged in the Meyer v. Nebraska law, but it overturned the Nebraska rule that German couldn't be taught in schools. And so you'll find very difficult to change any kind of foreign language instruction based on that legal precedent. And in other lectures, we've talked about the Lowell-Nichols case, which is the case from San Francisco, which required the school district in San Francisco to address the ELL students, the Chinese students, in their language and support them with the ELL programs that began to emerge as a result of that. And so de jure segregation of Chinese was outlawed in that case. The Plyer-Doe decision has to do with undocumented students, and this one is perhaps an instructional program, but perhaps a student rights. But undocumented students must be served by schools, and they cannot ask, law enforcement cannot ask the school about the immigration status. And the schools have to be protective of those students. And that became a major issue as ICE was doing raids that I dealt with as a superintendent in dealing with those ICE raids and some of our undocumented students. You don't ask them and you protect them. Evolution is also another area where the courts have been very diligent in supporting evolutionary biology and the theories of evolution. The Epperson v. Arkansas case, the Supreme Court invalidated a law in Arkansas forbidding the teaching of evolution. Generally speaking, grades and grading, as far as the reduction of grades for absences, have all been upheld by courts, that its grading policy was not beyond the district's scope of authority because of attendance. The grade reduction for academic misconduct is a little dicier, but a number of districts have formulated policies requiring grade reduction for academic misconduct that have been supported by the courts. The one area that's not been supported by the courts is withholding diplomas. School officials are delegated the authority to determine these diplomas. And in general terms, the school districts must award the diplomas even if the students don't participate in graduation.